All right, good morning and welcome to the Wisconsin Counties Association's educational webinar series on county board rules and conducting the county organizational meeting. I am Sarah Diedrich Hasdorf, Deputy Director of Government Affairs at WCA, and I have the pleasure of kicking off today's webinar and introducing our presenter for the day. Before I do that though, just a few quick words on how we will be conducting the session this morning. Our presenter intends to speak for about 45 minutes, leaving 15 minutes or so for questions. So if you have a question, please type it into the Q&A or chat feature at any time during the webinar. While we intend to wait until the end to answer questions, we will be monitoring the chat feature and the Q&A throughout the event. This webinar, along with others in the series, will be recorded and placed on the WCA website, along with the PowerPoint presentations. This week one of our educational webinar series on county board rules is designed to provide a general overview on county board rules, focusing on the items that should be included as part of your county board rules. As I'm sure many of you already know, a good set of county board rules can go a long way in ensuring the smooth functioning of a county board during the 2-year cycle. At this time, I'm going to turn it over to our presenter, who I'm sure needs no introduction, but I'm going to do one anyway.
Oh, I can't wait to hear
Phillips.
this. I can't wait to hear this.
Andy, it's always nice. So Andy Phillips is an attorney at the law firm of Von Briesen and Roper and also serves as general counsel to the Wisconsin Counties Association. Andy has dedicated his career to assisting counties with their most challenging legal problems. He brings innovative solutions to the organizational, operational, and personnel problems facing local governments. He is our go-to guy in all things related to county government operations, parliamentary procedure, and so much more. Andy will be joining us for all 4 weeks of the webinar series, along with some additional guests along the way. So Andy, thanks for being here today and take it away.
Thank you, Sarah, and happy Monday, everybody. So as Sarah indicated, this is part 1 of a 4-part series. The part 1 today is essentially an overview of what we've got with county board rules. So what do we hope to accomplish today? As Sarah indicated, a good set of county board rules can solve a lot of problems that we've got as it relates to issues of procedure on the county board. I can't tell you how many times I get calls, whether it be at the county board level or the committee level, that says, what do we do in this situation as it relates to somebody wanting something on the agenda? What do we do here? Is this out of order? What happens if somebody wants to bring a resolution back? And my first response is always, do you have board rules that address this situation? And if the answer is no, I mean, that's okay, because the body ultimately determines the rules by which the county board is going to take business up, or a committee is going to take business up. But if we have rules in place establishing, and it may not address what the decision is on a particular issue, but who makes the decision, that helps tremendously. And so I personally think that county board rules are a great help. You're not required to have county board rules. There's nothing in chapter 59, chapter 19, or anywhere else in the statutes that indicates you have to have county board rules. So I want to make this clear that what we're talking about today and the concepts we're talking about today, while I'm going to touch on some legal principles, it really is more or less my ideas and trying to get ideas out there so that you can have a discussion amongst yourselves on the county board, with corporation counsel, with your administrator, with your executive, with your administrative coordinator, about what are some different areas that we can address within county board rules, that we can make sure that we function as a really solid board and that we don't get too hung up on procedure. Understand that 5903 of the statutes, there's a lot of freedom contained within that statute. That statute is the administrative home rule statute. And essentially what that says is that unless there is an issue of statewide importance, counties are free to organize themselves and do what they will from an organizational standpoint without regard to what other counties are doing, without regard to whatever a state mandate is, for example, because there is no state mandates. And so we have the ability as counties to fashion our rules to fit us. And it's not one size fits all. That's the next bullet point. Different counties are going to do it different ways, and that's okay. And so like I always say, that as much as chapter 59 governs county government, and all 72 counties in the state are governed by chapter 59, there are 72 different ways that counties do business within the state of Wisconsin, and that's just fine. So you have to figure out what works best for your particular county. Coming on to today, we're not going to give you a template We're not going to say, here is a set of board rules, you should consider adopting these. That's not the purpose. Identify the key points. And hopefully the discussion today is going to help you to say, yeah, we're having this particular issue in our county. So how is it that we can best address that particular issue? Again, this is a launch point for discussions within your county. The process of going through and drafting county board rules is time consuming. The process for going through and revising county board rules is time consuming, and that's okay. If you put the work in now, you're going to find yourself with a much easier process down the road. And so we're starting this discussion in December. We know that every county in the state is going to have an organizational meeting in April next year. That's 4.5, 5 months away. So in 4.5, 5 months, you're going to have a discussion about how you organize to conduct business over the next coming 2 years. Now is a great time to dust off your county board rules, put it in the hands of a committee or a task force or some group of people from the board who are willing to take an honest look at the county board rules and say, are we doing everything that we can to ensure that our process is not only the right process, but it's written down so everybody knows it. So again, it's a launch point. If you have items that you want to share, because like I said, much of the discussion today is going to be, here are some thoughts for consideration based upon what I have seen and others have seen throughout county government over the course of the last 25 years. But if you have thoughts and if you have ideas, throw it into the chat, throw it in the Q&A. I'm going to be monitoring that as we go along here, and we can have a discussion about different points. So I want to start with this very basic concept, because I think people get confused from time to time about this. When we look at the source of our procedural rules as counties, we have an obligation to follow federal law, but federal law typically doesn't address process. We have an obligation to follow state statute. That does address process to an extent. State statute says, for example, that we have to follow the open meetings law contained within 19.81 of the statutes. And so we follow state statute, we follow federal law. If those are silent on a particular issue, we have the ability to adopt local rules. And those local rules take precedence over Robert's Rules of Order. Robert's Rules of Order are just guidelines by which to have a good organizational meeting, a meeting of a deliberative assembly. That's the terminology that Robert's Rules uses. But Robert's Rules also recognize that every deliberative assembly has the ability to fashion its own rules that are going to govern procedure. And that's what we're talking about with local rules here. And so local rules have the ability to trump Robert's Rules, all right? And that's an important concept. So when we talk about this concept of county board rules, the current board or committee takes a look at the rules now, between now and April, recommends amendments, and then you can adopt those amendments at the organizational meeting. Let's face it, the folks that are coming as new board supervisors in April aren't going to have a significant amount of input on the board rules to find out what works or doesn't work. So they, in my estimation, ought not be involved in the process of establishing new board rules. It ought to be the existing members of the board saying, here's what we've learned over the course of the last 2 years. Here's how we could make things function a little bit easier from a procedural standpoint. So let's look at our board rules now. Let's recommend amendments now, and then let's introduce and adopt those amendments at the organizational meeting or shortly thereafter. The other question I get asked, should the rules be incorporated in a county ordinance? I mean, they don't have to be. There's nothing requiring that they be in county ordinance. I think different people have different opinions as to whether they ought to be codified in ordinance. I happen to think that they should be. The reason I think that they should be is simply because there's a certain amount of permanence that happens with the county board rules once they're codified in ordinance. It takes an amendment to the ordinances to change the county board rules. The county board rules are then published as part of the ordinance publication process. They become part of the official law of the land. And so I think there is a tremendous benefit to having those rules codified within county ordinance. Now, there are others, like I said, who may disagree with me, and that's fine. There are reasons that others feel that they ought not be in county ordinance. Either way, let's make them permanent, and nothing is permanent until you write it down. So let's write down our county board rules. And if we do not adopt them by ordinance, at least have a resolution on the books that indicates what those county board rules are. And so I've been involved in, I'm trying to think, it's a number of either amendments, redrafts, or drafting of county board rules for various counties over the years. And from what I have seen, you can basically break the board rules into 3 different chapters, if you will. 1 dealing with county board officers, 2 dealing with organization of the board, and 3rd dealing with the procedural rules of the county board. You don't have to follow this. This is, again, not designed to be a plug and play template, but this is more or less how I have seen county board rules organized over the years. So we're going to deal with each of these chapters as we go on in our discussion today. So let's talk first about county board officers. Now, we know by statute that we have to select a chair and a vice chair. You have the ability to elect a second vice chair, and many counties have done this. And so we know that by statute, we have to have 2 officers, the chair and the vice chair. Anything beyond that is discretionary on the part of a county. Some counties, as I mentioned, elect second vice chairs. What about a sergeant-at-arms? My old colleague, Mike Blaska, used to say that sergeant-at-arms is a critical component of your board officers because the sergeant-at-arms maintains order and solid procedural order at a meeting. And so it's very important that you have somebody designated to maintain that order. And Mike is, of course, the former board chair in Dane County. And so I have not done a survey to know how many counties utilize a sergeant-at-arms, but that is certainly an option that you can consider for your county. The chair and the vice chair are elected at each biennial organizational meeting. So coming up in April of 2022, there will be a process where the board elects a chair and a vice chair. And then if there are additional officers of the board, they can be elected at that organizational meeting as well. The chair and the vice chair serve 2-year terms or until successors are chosen. So what happens if we have a problem with our officers? Well, we know that by state statute, and it's in 5912, I believe, we know by state statute that the board chair and the board vice chair serve at the pleasure of the county board, meaning that at any time during that 2-year period, the board has the ability to unseat the board chair and elect somebody else board chair. That was the topic of an attorney general opinion. I believe it was from Walworth County, where the question was asked, do we have to have a 2/3 vote or have cause in order to remove the board chair? And the attorney general said, no. If you look at the statute is quite clear in that that board chair serves until a successor is elected, period, meaning that the board at any point in time may elect a successor to the county board chair. That doesn't mean that we can't better define the process by which removal is going to occur. In other words, are we going to require a board resolution? Are we going to ask that somebody wanting to bring a motion to remove the board chair or replace the board chair file a motion in advance with the clerk? In other words, if there's dissatisfaction with how the board chair is operating within the county board, what is it that that person needs to do in order to get that question before the Board of Supervisors? That's a process question that you can develop within your county board rules. Duties of the chair, we look again at 59.12. And all of you have probably heard me speak at length about roles and responsibilities and the role of the county board chair. And the county board chair is the leader of a legislative body, the legislative body in county government being the county board. And so when we look at the duties in 59.12, as it relates to the chair, administer oaths, countersign ordinances, preside at meetings, and so on. But I want to focus a moment on that first bullet point, perform all duties required of the chair. Well, how do we get to an understanding of what duties are required of the chair beyond what the statute allows? That again can be informed by the county board rules. And so if you have a particular process within your county where the chair, for example, sets the agenda for board meetings, put that in your county board rules. That's a duty of the chair. And so again, 59.12 says, when directed by ordinance, countersign county orders, transact business with local and county officers, expedite measures resolved upon by the board, and take care that all other laws and regulations are enforced. All right, so again, those are very broad topics, but right there in statute it says when directed by ordinance. Well, if we codify our county board rules in ordinance, we have the ability to direct the county board chair to perform certain functions within the county, and we can specify what those functions are. And again, we have tremendous flexibility as counties. 59.03 gives us tremendous flexibility as it relates to coming up with that list of items that the board chair is going to be required to do. For that matter, we can do the same thing as it relates to the vice chair. So we create the offices, all right? We say that there's going to be a chair, there's going to be a vice chair. And let's, for example, say that we're going to have a sergeant-at-arms. Let's give those particular positions descriptions. Let's give them job descriptions, position descriptions to say, here is exactly what these individuals are going to do if they are elected to serve in this capacity. When we talk about the duties of the chair, I want to clear up some misconceptions that we have seen over the years as it relates to the way that Robert's rules, local rules, and state statutes come together. The question always comes up because Robert's rules says that the chair of a particular deliberative assembly ought not vote except in the circumstance of a tie. We also see that in Robert's rules, the chair of a particular deliberative assembly ought not debate on matters that come before that deliberative assembly, because then it shows some sort of bias on the part of the chair, and the chair is supposed to be impartial in presiding over that deliberative assembly. That's where, as counties, we deviate a bit from Robert's rules because, of course, the board chair was elected to represent a particular district within the county, and it would not be appropriate for the chair to simply neglect advocating for the interests of the electors that put the board chair in that particular seat, just because the board chair also serves as the chair of the Board of Supervisors. And so the board chair, at least in terms of what we are accustomed to and what should happen, board chair maintains the right to vote, maintains the right to debate. And there's a little bit of gray area as it relates to when the board chair needs to pass the gavel, so to speak, to engage in debate. And I think the board rules can do a good job of defining when it is that we would expect the board chair to pass that gavel. We have a question already. To remove the board chair, if the chair sets the agenda and doesn't want to be removed, how do you start the process? That's a question that I get all the time. And so going back to this question of how do we deal with the removal process for the board chair? If the board chair sets the agenda, what's the likelihood that a removal motion is ever going to get onto the agenda? It's very unlikely. So should there be a provision within the board rules which provides that a member of the board has the ability to bring a motion to remove the board chair independent of what the board chair thinks ought to be on the agenda? Again, you can provide for that within the county board rules. Now, there is a statute on the books that indicates that a special meeting, I think it's in 59.11 of the statutes, where a special meeting may be called if half of the supervisors or more than half sign a petition and indicate what ought to be on the agenda. You can do that, but what I'm saying is that the board rules can provide some sort of additional procedure to get something like that on the agenda. Again, when we talk about duties of the chair under 59.12, does the chair independently appoint members to committees? Is the chair's appointment going to be subject to confirmation by the board? In other words, what is the process for getting members on committees? And each county does it a little bit different. Some of the boards that I've seen utilize a committee on committees to determine who is going to be serving on committees. Address that in the board rules. Can the board chair serve as the chair of other committees? For that matter, does the board member serve on all other committees of the county board in an ex officio capacity? Ex officio means by virtue of that person's office. And so if it simply says ex officio on all other committees, well, if you follow the definitions and follow Robert's rules, that means that the board chair can debate, vote, and is counted for quorum purposes on all other committees. All right. So I think there's a common misunderstanding of what ex officio means. But let's specify in the board rules what we mean by that. Does that mean that the board chair has the ability to vote, to debate, or is it merely the board chair has a right to attend all of those committee meetings? Let's specify that in the rules. All right, before we get on to duties of the vice chair, other questions? Okay, we've got those. All right, so then the vice chair fills in when the chair is unable to perform duties of the chair because of his or her disability or absence. And this is an important part of this, is that it should be automatic, and that in the absence of the chair, the vice chair has the legal ability to act as chair. Act as chair, not become chair, but act as chair, okay? I often get the question, if we have the board chair, for example, the board chair passes away in the middle of his or her term, does the vice chair automatically ascend to the office of chair? Well, no, by statute, there has to be some sort of an election so that the vice chair would become the chair by virtue of being elected chair by the Board of Supervisors. That's the way it ought to go. The board rules can provide, however, that the vice chair automatically ascends to the office of chair if that's what you desire to happen in your county. Now, I happen to think that it's probably not a great idea to have that automatic ascension occur, because the body voted for a particular person to be chair, and the body voted for a particular person to be vice chair. The body never indicated that it wanted the vice chair to be the chair. Let's go through another vote in order to determine who ought to be chair, because circumstances and things may change. And so the body ought not be handcuffed into automatically having the vice chair be the chair. So I always like it where the vice chair performs the duties of the chair in the chair's absence. But then if we have the chair's absence become permanent because of death or resignation, whatever the case may be, we're going to have an election for the office of chair to carry out the duties of chair for the balance of that particular term of office. If you have a sergeant-at-arms, what can be the duties of the sergeant-at-arms? Well, like I said before, the sergeant-at-arms is designed as a position to keep order at a meeting. And so the sergeant-at-arms is going to perform duties as directed by the chair, such as gathering members for the start of the meeting, remove unruly members of the public, notify members of the public or members of the board of special events or procedures, contact department heads to make arrangements for them to present reports at the meeting, distribute literature that is provided at the meeting, and so on, things of that nature. So there we've got the officers. And again, beyond chair and vice chair, you have a lot of flexibility as counties in determining what officers you're going to have and what duties they're going to perform. Understand as well that the duties of chair and vice chair, there are some spelled out in statute, but you can certainly supplement what is spelled out in statute by virtue of an ordinance. And if you codify your board rules in ordinance, that is exactly the type of ordinance that can define what it is your chair and vice chair do in addition to what's contained in the statutes. So now let's talk about organization of the board a bit. When we talk about organization of the board, we're talking about the day-to-day operations of the board. And we know that county boards get together once, maybe twice a month. And when the boards get together, that's really high-level stuff, where at a high level, you're debating resolutions, passing resolutions, listening to high-level reports, and going on. The real, get your elbows working and your fingers dirty work of counties happens at the committee level. So what standing committees are we going to have? What committees are going to be there for the entire balance of the term of the board? I'm thinking about the finance committee, perhaps an executive or administrative committee, your human services board, obviously, zoning committee, the ones that are always going to be there. All right. There may be other committees that you want to form from time to time for a particular purpose. And we will get into that in a moment, but let's identify those committees that we know are going to be there, those standing committees. And then let's give them a job description. I'm constantly going to remind folks about this, is that you cannot underscore enough the importance of job descriptions, whether it's board officers, committees, whatever it is, let's identify the charge of the committee within the board rules. And then if we're going to have other committees, what is the process for creating another committee? Does the board chair have the ability to create an ad hoc committee? Does it require board confirmation in order to do so? Answer those questions within your board rules. Let's talk about this concept of staff assistance. What is the expectation when it comes to committee meetings and board meetings as to when department heads and other staff are going to be available to provide information to the policymakers? Let's talk about how we schedule a meeting. What type of notice is required? That's very important because, as I mentioned earlier, if we've got a board chair in charge of the agenda and we want to remove the board chair, how could we ever get that on the agenda? Let's identify that issue and spell out in the board rules exactly how that happens. For that matter, take away this whole removal of the board chair concept, but let's say there's an agenda item the board chair just doesn't want to put on the board agenda. What's the process for getting that particular piece of business before the county board? There ought to be a process for doing so. I will note here that one thing I don't like is just any individual supervisor having the right to demand that something be placed on the agenda. There ought to be some level of support for something being placed on the agenda. And so you have to decide as a county what level of support will be required to get something on the agenda. But I think it should be more than just one particular board supervisor saying, hey, I want in the agenda a discussion about a trip up into space. I heard that there's this really cool new thing out there where you can pay some money and go up into space. I want to put that on the agenda and debate that. That's not appropriate unless there's significant support for that type of initiative. So let's identify what that significant support looks like. The other thing is a notice issue. We don't like to be surprised in county government. We don't like to be surprised at board meetings. We ought to have an understanding of exactly what is going to be on the agenda and what we're going to be doing. So let's have a notice provision within our board rules about when items come before the board chair or the clerk or whatever the case may be to get on the agenda, that advance notice is given as to that matter coming. The other thing is conduct. What's our expectation as it relates to how we relate to one another at the board level and at the committee level? I often get asked, should your ethics code be placed in the board rules? And I think no, because I think ethics codes are separate, but I know that there are provisions within board rules that speak to what we consider to be ethical conduct. When I talk about code of ethics, I'm talking about 19.59 stuff, the stuff that is going to lead to a question of whether that particular supervisor or county official violated the ethics rules. That's different than how we treat each other inside a board meeting. What are our rules of decorum within that board meeting? How are we going to conduct ourselves? What is the process for public appearances at the committee and county board level in terms of public comment and others that present information to the board? What are we going to demand of the public? What are the minutes of our meetings going to contain? What's the format? What's the information? And that again is going to be driven in large part by your county clerk, because your county clerk under 59.23 of the statutes is responsible for those minutes of the meeting. And so have a conversation with your clerk and determine what minute format is going to look like, and then put that into ordinance so that we have an expectation out there of what those minutes look like. What is the budgetary review process? In other words, we have a very big document that is the preeminent policymaking document within our county. What's the process for formulating that budget? Fiscal notes. Are we going to require fiscal notes on every resolution? Legal notes. I've seen corporation counsel review required of all resolutions, which I happen to like quite a bit, because corporation counsel is going to be able to identify inconsistency and problems within resolutions. But what is our process for attaching fiscal notes or corporation counsel notes to those particular resolutions? Again, that can be in the board rules. So, as I mentioned, standing committees, you can establish as many standing and advisory committees as you deem necessary. And from what I've seen, based upon my review of several county websites over the years, some of you have taken full advantage of this freedom, because I have seen no less than 60 some committees in some counties. Is that efficient? I'll leave that up to you as to whether you think it's efficient. I happen to think it probably is not. But you have the ability organizationally to establish as many committees as you would like. Now, I will just plug part 2 of this, because I think part 2 of this coming up in the next couple of weeks is going to be a discussion of committee organization within a county. And so I want you to come back and listen to people other than me who have been through this process of establishing standing committees and really studying and looking at how many committees are necessary to do what we need to do as county government. As I mentioned, let's establish a charge for all of the standing committees. Let's establish the job description, what it is that they're going to do. And we look at what they are going to do. There are certain elements that should be common to every single one of the standing committees. Policy oversight, provide policy direction and make recommendations, monitor certain activities, act as a liaison between a particular department within county government and the board, review budget requests, whether it be amendments or a request to exceed budgetary authority. You review all of those at the committee level and you provide advice to the county board as it relates to matters of policy. We want to have an odd number of people if possible on those committees. We want to specify the number within our board rules. And then again, we want to specify the appointment process. Some counties do it board chair, some with board chair with board confirmation, some full board elects, some have a committee on committees that establish. It's up to you as to how you comprise that particular committee and all of the standing committees within your county. Can you have members on multiple standing committees? Absolutely, you can. It's up to you as to the rules that you want to define to utilize that. Specify who the officers of those committees are: chair, vice chair, recording secretary. Note I've got there in conjunction with the county clerk. Remember, the county clerk is responsible for the minutes not only of the county board, but all committees of the county board. But we also know that in some of the smaller counties, the clerk does not have a vast staff that can actually attend all of the committee meetings. So oftentimes you're going to have department heads that serve as a recording secretary for a particular committee. And that's just fine. And that's very efficient. That's great. But there ought to be a format and a job description for that department head serving as recording secretary. What's the removal process for taking somebody off of a committee? If the board chair appoints, the law recognizes that the appointment power comes with the removal power comes with the appointment power. So in the absence of anything in your board rules, if your chair appoints committee members, your chair has the ability to remove committee members. Is that the right answer? It might be. It might be. It's up to you. But if you want to deviate from that default position, you ought to specify what that removal process is within the board rules. Again, is the board chair a member of the committee, and are there any limitations on voting? I've seen in several counties this provision where the board chair has the ability to serve on behalf of another member of a committee who cannot make a meeting. And so if we've got somebody who can't make a meeting, the board chair has the ability to fill in. I like that a lot. I don't like the automatic board chair is a member of every committee, has the ability to debate and vote, and is counted for quorum, because I think that's just too much for a board chair. There are obviously particular committees that the board chair is going to be a very important part of. I'm thinking of executive, perhaps finance, as the two that come to mind right off the bat. And so you want to specify within your board rules that the board chair is a part of those committees. But in terms of overall, specify within your board rules when it is that the board chair has a right to attend meetings and has a right to vote and so on. I'm just looking and seeing what we have here. We have a couple of questions here. Let me just take a second and address these. Does a sergeant-at-arms need to be a board member? Technically, no. The sergeant-at-arms does not need to be a board member, but I don't know if an individual who's not a board member, if that individual is appointed sergeant-at-arms, if they're going to have the requisite authority in the eyes of the board to enforce the board rules. And so I think, just, and again, this is my personal opinion, I would rather see a member of the body being designated sergeant-at-arms. I mean, if things get too unruly, you can always have a sheriff's deputy or the sheriff, him or herself, be there and enforce the rules. That's kind of a heavy-handed approach, which frankly might be appropriate in certain circumstances, but probably not all circumstances. But if you feel it's important to have somebody designated to be the order keeper, so to speak, for the board, I would rather it be somebody who is a member of the board. And that member of the board then would sit up at the executive table, so to speak, with your board chair, vice chair, and if you've got one, a second vice chair, and of course, corporation counsel and clerk and others. Next, does an appointment need to be locked in before serving or voting? Yes, an appointment needs to be final before the person is given the appropriate authority to act. And so if there's an appointment process, for example, with committee members and it requires board confirmation, if your board chair appoints somebody to a committee, that person's not on the committee until the board confirms. And so it's only after the board confirms that that individual would be eligible to serve on the committee and otherwise vote and participate in debate. All right, returning to standing committees. Again, job descriptions are critically important here. And then let's specify, do we have non-elected persons serving on a committee? Let me take, for example, the Human Services Board. We know that there are citizens from the general public, not board members, that are required by statute to serve on the Human Services Board. And so are we going to define if there are any limitations on what those individuals can do on the Human Services Board? I'm not saying it's appropriate, not saying you have to, but I've seen counties that have defined certain limitations. Likewise, we may have a program where we allow students, high school or college students, to serve on particular committees, and they do so in a capacity where they just want to be informed, and we want their input on certain things, but we don't want them to vote. And we may not want them to engage in debate on certain matters either. So let's specify within our board rules what those limitations may be. We know that we also have this statutory highway committee. This is an example. I put this up here not to tell you how to organize your highway committee, but as an example of where other statutes have created obligations when it comes to us creating these committees. But you'll see that even within the statutes, we have incredible flexibility. So notwithstanding what we have in paragraph 1A as it relates to the highway committee, in 1C, it says that we as a board may fix the number of members on the highway committee, the membership, the manner of appointment, the method of filling vacancies, and the terms of the members. All right. So we have to take affirmative action to take ourselves out of this 1A, because the 1A is the default. And so if we don't have a board rule dealing with the highway committee, we have to follow 83015 sub 1 sub A. But if we have a board rule, we have incredible flexibility for defining how it is that our highway committee is comprised, who the membership is going to be, what's the manner of appointing them, how do we fill vacancies, and what their terms will be. Ad hoc committees, and I mentioned before that I've seen county websites that have 60 some odd committees on there. A lot of those committees, vast majority of those committees, are what I would consider to be ad hoc committees. They're formed for a particular purpose. And so if we're going to form ad hoc committees for a particular purpose, which I think is very important, I think there are issues that arise from time to time within counties that require some sort of particular review or particular expertise to handle a particular issue. So ad hoc committees are really, really important, but let's define how ad hoc committees are created. And let's specify what it is that is going to create them. Is it going to be by resolution? And if it's by resolution, we want to make sure that resolution contains the charge. What are we asking that committee to do? And then also, let's make sure that we understand when that committee is done. When is that ad hoc committee? When is it disbanded? When is its purpose over? So let's specify that in board rule. Staff assistant. Again, we want to speak to this concept of department heads providing assistance to the policymakers, staff providing assistance to the policymaker. If they are going to serve as the recording secretary, if they are going to help in preparing and posting agendas and taking minutes, what is the process for consultation with the county clerk's office to make sure that we're doing everything consistently across the county? Understand that we have an obligation, not a choice, an obligation to comply with the open meetings law. And so we want to be very particular about how it is that we make sure that we comply with the open meetings law. Ultimately, in the law, in the open meetings law, it is the presiding officer in charge of the board, in that case, the board chair, or in charge of a committee, in that case, the committee chair, who is responsible for open meetings law compliance. But I will tell you, in the vast, vast majority of counties I've been in, the open meetings law expert is the county clerk. And so make sure that we have coordination with the county clerk, because the county clerk is responsible for posting, publication, whatever it is that you do as a county to provide notice to the public of a particular meeting of a committee or the county board of supervisors. And so there ought to be something in the board rules that indicates how an agenda is posted, how agenda is created, what kind of information is on there. When we talk about what kind of information is on there, what are we requiring in terms of closed session? Because you have to be very specific when it comes to creating an agenda as it relates to closed session. All right. And so Again, I like to have Corporation Counsel review all closed session items on an agenda because Corporation Counsel is the one with the legal background to determine sufficiency of the notice provided to the public. So have that process within your board rules. Specify when we post agendas. Remember, the law says that it's a minimum of 24 hours, 2 hours in the event of an emergency. But that's the minimum. Just because the law allows us to wait until 24 hours before the meeting doesn't mean we should do it that way. And so let's have a process within our board rules that provides for some sort of advance notice. Again, nobody likes surprises. So let's make sure that we have an understanding of exactly what type of lead time is going to be required to get that agenda final and posted out there. Public appearances. I get this question quite often as it relates to public comment. There is absolutely nothing in state statute that requires public comment. Nothing. You do not have to have public comment on your board agenda or your committee agenda. It doesn't have to be there. Now, I'm not talking about required public hearings. We know that there are particular statutes. For example, 59.69 requires a public hearing in the event that you're going to change your zoning ordinance. I'm not talking about that. I'm just talking about as a general matter, you're not required to have public comment on your agenda. But if you do, if you want to have public comment on your agenda for each county board meeting or each committee meeting, then what are the rules associated with public comment? Do we have rules of decorum? Are we going to require that the speakers address topics that are germane or relevant to the agenda of that particular board meeting or committee meeting? Are we going to limit the amount of time that somebody can speak? Are we going to allow supervisors to comment during public comment? Things of that nature ought to be addressed within the board rules. Because again, once it's in the board rules, then we have the ability to tell the public, you're out of order with this particular comment because it's not germane to the agenda. And our board rules require that public comment be germane to the agenda. But if you don't have a board rule on that, it's dangerous to limit public comment because of course we're dealing with an individual's First Amendment freedoms. So again, there we get into some legal issues. So if we address this up front with the board rules, we're much better off. Again, this is going over things that I just talked about. I want to spend a minute on the last bullet point here on this slide, though. Board members should not be allowed to discuss or participate in debate if not members of the committee. And I get that question quite a bit. We've got board member who's very interested in a particular topic, but board member is not a member of the committee where this topic is going to be discussed. So board member shows up at the meeting, has a seat at the same table as the rest of the committee and decides that he or she wants to engage in debate and otherwise discuss this particular issue with the committee. Does the board member have a right to do that? No, there is no right to do that. And so you want to specify within your board rules, if we're going to allow participation, when is that participation allowed and at whose discretion? Is it a matter for the committee chair to say, yes, board member can attend this meeting and participate in the discussion? Or is it up to the entire committee where the committee has to take a vote to allow that person to engage in the discussion? Again, address that in the board rules. Because in the absence of anything else, the board member has no right to participate in that particular discussion. And then the board member has to rely upon a public comment period to make his or her views known. It's okay. Board members should be allowed, or they have to be allowed to comment during a public comment period because that board member also has First Amendment rights to speak to the committee or speak to the board. And it's not the board because they're already board members, but speak to the committee. But I think it'd be much better and easier and cleaner if we address non-committee board member participation in committee meetings in our board rules. Should we require members of the public to register before speaking? I like that because then we have a record of who's speaking on what agenda item and what topic. So I like a registration requirement. Other counties where it's smaller counties, for example, a registration requirement might be too cumbersome, and that's okay too, but you have to figure out what your process is going to be. Are members allowed to ask questions of the particular speaker? So for example, we have a public commenter who's talking about an issue. Can members of the committee or members of the board ask questions of that commenter? Again, we're getting into an area that requires evaluation of open meetings law requirements, and Corporation Counsel is probably going to have a little bit of heartburn suggesting that members can start engaging in a discussion with a public commenter, especially for an item that's not on the agenda. So be careful about this, but I think you want to specify in your board rules that if you want everybody to remain silent while the commenter is speaking, then let's put it in the board rules. Minutes of the meeting, and we have an entire session devoted to what should be contained within the minutes of a meeting. So I don't want to spend too much time on this entire minutes of the meeting concept, but let's remember that the minutes associated with a meeting have to record the official action of the committee or the board, not what was said. We're dealing with what is done, not with what is said. So coordinate with your county clerk, come up with a format, and then specify that format within your board rules, because once it's codified in ordinance, everybody understands exactly what those minutes ought to look like. Budgetary reviews, I talked about this briefly. Again, if there is a process that you follow as a county where different committees and different people are looking at different aspects of the budget for its presentation to the board, then look at that. We know that in counties with an executive, the executive presents the budget to the board. We know in counties with an administrator, the administrator presents a budget to the board. But I will tell you, in several counties with an administrator, there is a process whereby the administrator presents portions of the recommended budget to committees that are going to be rolled up then into an overall budget before the board. So if you have that type of process, put it in your board rules so that everybody has an understanding of the calendar associated with budgetary oversight and formulation, and then understand what roles and responsibilities are as it relates to budget formulation. Oh, this is an important point too, before I gloss over it. Each committee monitors the current year's budget. Specify that within your board rules, within the responsibility of the standing committees. If we have a committee, the highway committee, for example, ought to be looking at the current year's budget and having a discussion with the highway commissioner about budget performance. That ought to be part of that committee's responsibility. Fiscal notes and legal notes, I talked about this a little bit. I think it's important that we have finance or others weigh in on what the cost to the county would be of a particular resolution or measure, and the same with the legal note. I highly recommend having resolutions go through the corporation counsel's office for sign off before they're introduced to the county board. And then we get into procedural rules. How is it that we're going to interact with one another at the board level? And so when we look at county board meetings as a whole, we want to address rules of decorum. We want to have a particular form of agenda, a flow, if you will, to each of the county board meetings. We also want to have resolutions take a particular form, so we have an expectation of what a resolution is going to look like when it comes to the county board. Is there going to be a referral process on all new resolutions? Referral meaning the resolution is introduced at the board level, and then the chair, with the board's consent or without the board's consent, again, up to you, but then the chair refers a particular measure to a committee. What do the committee agendas look like? What's the standard format? What is the process for taking county board action on resolutions? And for that matter, what is the seating arrangement for the county board? Is that determined at every biennial organizational meeting? When and under what circumstances can it be changed? Does an individual board member have any sort of role in the process for determining seating assignments? And so again, we're getting into some of the procedural details here, and you can see that this bullet list gets pretty lengthy when we start thinking about this. So think about how it is that your agenda should look. Think about what the order of business is. Think about the rules of conduct that are going to apply to our board meetings. Think about our voting process. Do we have electronic voting? Do we not have electronic voting? How is it that a member can request a roll call vote? Define a session, and this is important as well, because in my opinion, and this is my opinion only, a session of the county board begins at the April organizational meeting and persists until the next April organizational meeting every 2 years. That's a session of the county board. Why is that important? Because it defines when certain matters under Robert's rules can be brought back to the body for reconsideration and things of that nature. And so define a session within your county board rules. I know some counties consider each and every meeting a separate session. And that's fine. They define it within their board rules. And I might like to have a discussion with those counties about how that could be an impediment to getting some things done, but at least the session is defined. Define parliamentary procedure. Are we going to follow Robert's rules, latest edition? If so, specify that within your board rules. And then interpretation of the rules. We know that during a meeting, the board chair or the committee chair makes determinations on issues of parliamentary procedure and application of your particular board rules. But if you want to have a different process on interpretation of those rules, if You want to have corporation counsel weigh in on interpretive issues, then specify within your board rules what it is that you want to do to make sure that corporation counsel is given that opportunity. In our board rules, we specify dates and times for every single county board meeting on the third, for example, on the third Tuesday of every month, the county board shall meet. What is it that we have to do to cancel meetings or call special meetings? I addressed this early on in this discussion, where as a body, if we have more than 50% of the members petition and have within that petition the item of business that they want for a special meeting, those members have the ability to call a special meeting. But shouldn't we have the board chair have the ability to call a special meeting from time to time if circumstances warrant? I think that'd be a good idea. And I think that needs to be in your board rules. Specify rules for the committee of the whole. I know some counties adjourn their board meetings into committees of the whole so that they can debate and discuss a certain topic before, again, adjourning the committee of the whole and going back to the full board to take action on a particular item. So what are the rules for a committee of the whole meeting? Are we going to allow the chair to schedule public hearings? Because as I mentioned before, there are certain items within Wisconsin statute that require a public hearing. So are we going to give the chair the authority to schedule these types of public hearings? In 5902 sub 2, we take action as a county board by ordinance or resolution. So let's have a form to those particular documents. That form ought to be put together with input not only from the board chair and the board itself, but corporation counsel, finance, county clerk. In other words, there are other constituent parts of county government that ought to have input on what type of form makes sense. Define the introduction process. How do we get a resolution before the county board? Do we submit it to the county clerk, to the board chair, to a committee? Do we have deadlines associated with that submission? Do we allow for co-sponsors? You see this at the state level with the Assembly and the Senate, that those particular individuals, the assembly persons or the senators, circulate these co-sponsorship memos and ask for others to sign on a particular piece of proposed legislation. Do we have that process within the county, or is it simply one supervisor who can introduce a particular resolution? Drafting ordinance amendments. It ought to be corporation counsel. I know you have the flexibility to define somebody else, which is why I put a question mark after corporation counsel there. But in my estimation, it ought to be corporation counsel who's drafting all ordinance amendments. The ordinances, the county's code of ordinances, that's the law of the land as it relates to that your particular county. The law of the land is an incredibly important part of the county, and you don't want ambiguities within those ordinances. You don't want inconsistencies. So have corporation counsel draft your ordinance amendments. Same token, designate one person to draft budgetary amendments, whether it's your administrator, your finance director, your controller, somebody is in charge of budgetary amendments. Referral. They should go to a committee before they go to the county board. So what's the process to refer a particular resolution for further study and consideration? I like a process where the chair, him or herself, refers a matter to a committee. You can have it where a committee makes the determination of where to refer it, but to me that seems like a rather lengthy process. And so I much prefer the simplicity of just having the board chair refer, but again, it's up to you as to what process works best in your county. If we have a particular supervisor that is advancing a particular piece of business via resolution before the board, in other words, it's a board supervisor's, one supervisor's resolution and says, I want to do this, then invite that board supervisor to the committee to address the particular matter that is being advanced with that resolution and put that process within your board rules. Committee agendas, same as board agendas, specify date, time, place, and matters to be discussed. All resolutions ought to have a number and title. So when the committee gets a resolution, you attach a number and a title to that particular resolution. Again, consult with your county clerk as to the numbering nomenclature and the numbering process. Specify if the chair of the committee has the discretion to place items on the agenda that have been referred, or if the committee chair has an obligation to put matters on the agenda, specify that within your board rules. And if a certain period of time passes after referral, does the matter get automatically referred back to the board, or does it die? I often get asked that question. What happens on a resolution that was referred that never comes back to the board? And Robert's rule says that the body, the board of supervisors, has the ability to call the item back to the board, but it requires affirmative action from that body. You have to take a vote to bring that matter out of committee back to the Board of Supervisors. Your board rules can provide, provide a process whereby an item of business that's not acted on at the committee level can automatically come back to the Board of Supervisors. So specify that. Can committee members call special meetings? If so, how many members have to petition or agree that a special meeting ought to be held? Does the request have to be in writing? These are some of the questions that you can answer within your board rules. Resolutions and county board action. Define the process for placing resolutions and other items on the agenda when the committees have acted. So is it automatic where once the committee has acted, it comes out of, for example, the executive committee and automatically gets placed on the board agenda? How does that process work? Again, in trying to simplify things, you can have, if you've got positive committee action on a particular resolution, Robert's rule says you don't need a formal motion and a second. And so placing it on the agenda that such and such committee recommends adoption of a particular resolution, that in and of itself is a motion and second. So in an effort to try to create efficiency in the process, when you get to that item on the agenda, the board chair can simply say, the highway committee is recommending that we purchase a new highway patrol truck in the amount of $46,000. And I know at that amount, I'm living in a fantasy world, but let's just pretend for a moment. And that matter on the agenda can automatically be up for debate at the Board of Supervisors level. Another question, pending resolutions, ordinances, and ordinances amendments. Are those automatically carried forward to the new board after the county organizational meeting? That's an open question. That gets back to that question I had earlier about defining a session, because once the session ends, anything that hasn't been adopted, so to speak, dies. In order to bring it before a new session, you have to have a new motion, a new resolution, a new ordinance amendment. And so if you want carryover, which I think in many circumstances makes a ton of sense, if you want that carryover to happen, specify that within your board rules. The county board has the ability to discharge a committee that fails to act. What is the process for discharging that committee? Requiring certain amendments and actions, requiring them to be in writing clarifies what is intended by a particular action. Again, it would be my recommendation that you work slowly when it comes to things like amending resolutions or amending ordinances. And the reason you do that is you want to make sure the county clerk and the presiding officer, the board chair, understand exactly what is intended by a measure amending an ordinance or amending a resolution. And one of the ways that you can assure that the intent is met is to require that all of it be in writing. Seating arrangement, designate the process for seat selection, or if it's going to be according to exactly how you have a chart, put that chart, for example, into your board rules. Designate a place for the public, designate a place for staff, corporation counsel, county clerk, administrator, department heads, sergeant-at-arms, and other folks that are involved in a county board meeting. Designate where those folks are going to sit. Does the chair have sole discretion for placing items on the agenda? Under Robert's rules, the chair is responsible, and under the open meetings law, the chair is responsible, but there ought to be a process in place for others getting items on the agenda. What does that process look like within your county? Designate it within your county board rules. Answer some of these questions. Should all items acted on by a committee, should they automatically be on the board agenda? Do all items have to go to a committee before being considered by the county board? Is there a deadline associated with submission? Should all resolutions items be in a resolution format? I mean, the answer to many is yes, you ought to have a process, but I'm not going to tell you what that process has to be. You have to figure out in your county what works the most efficiently and what works the best. We have an agenda and order of business. This is an example that you can use within your county. Whatever you use as an order of business, put it within your board rules so we have continuity as it relates to the agenda for the Board of Supervisors. Conduct at county board meetings. This is really important. It's important because we want to set the expectations for that meeting, not only for the board supervisors, but anybody else attending that meeting. So establish these rules of conduct that are going to be the rules of decorum that are associated with the county board meeting. Let's put them right out there so everybody's expectations are set. Voting, there is a process for voting. Are we going to have a roll call vote? And does somebody have the ability to call a roll call vote in the event that we don't vote on matters electronically and so on. Specify that within the board rules. We've talked about session a little bit. Parliamentary procedure, again, within your board rules, designate the latest version of Robert's Rules of Order, newly revised. Currently, it's the 12th edition, but who knows when the 13th edition may come out. It may be next year, in which case, if we designate within our board rules that we always operate on the latest version of Robert's Rules, we will be covered. So I'm at 9:59, leaving us 37 seconds for questions. And I kid, of course. I will stay on as long as anybody has questions or wants to discuss these. Before, I don't see any pending questions in the chat or the Q&A. So if you have questions, feel free to put them in either chat or Q&A. Before I do that, Sarah, do you want to maybe just briefly, while we still got folks on, talk about the next 3 sessions that we're going to have?
Yep, absolutely, Andy. That's what I was going to do to fill the time to allow folks to type in their questions. And to remind folks too, we know we went through some of this relatively quickly today, but we do have other opportunities coming up over the next several weeks to go into a lot of these concepts in more detail. So week 2 is next Monday, December 13th, same time from 9 to 10, where we're going to talk about committee structure and right sizing. Andy will be joined next week by Steve O'Malley, the La Crosse County Administrator, and Jason Zwino. I know I'm going to mess up his name multiple times this week. Zwinell, thank you. I know I'm going to mess it up this week and next week, who's the Ozaki County Administrator. Week 3, then we take a couple of weeks off for the holidays. Week 3 will be on Monday, January 10th, again from 9 to 10 a.m., where we're going to talk about rules of decorum and procedural rules. That's where we're going to get into a little more into the nuts and bolts of the details of your rules. And then finally, our last week will be on a Tuesday, not Monday. We know a number of counties are closed for MLK Day. So week 4 will be on Tuesday, January 18th, where Andy's going to talk about conducting the county organizational meeting. So awesome. Andy, are we seeing any? I'm not seeing any questions. Are you?
I am not seeing any. So thank you all very much for being on board with this really important topic. Board rules, it's not something that you put on the top of your I want to do list, but this is important stuff. This is really good stuff. And the counties that have gone through this process in a deliberative fashion, I think will tell you that after getting through this process, their meetings and their procedures and everything run much smoother. So I'd really, really encourage counties to take a hard look at their board rules. If you don't have board rules, create them. If you've created them, update them. I think it's a very important part of what we do.
All right, I'm not seeing any additional questions pop into the chat or the Q&A, but again, folks can feel free to contact our office or contact Andy Phillips at any time if you have questions with regard to what was discussed at today's webinar or any of our future webinars. Otherwise, we look forward to seeing you next week. Until then, have a great rest of your week.
Thanks, everybody.